Yes. How is this a ground to review?
Yes, there are two grounds. In fact, if my lords may just have the order first. That is the order which we seek review of. That is on page 18 onwards.
Yes.
My lords may kindly have para 2. This we say was not properly represented before the bench, probably because of some misrepresentation on our end, because my lords will always see the petitioner was trying to prosecute her case first, and then of course an amicus was appointed later on. Be that as it may. Para 2 says, brief facts of the case are as follows. The petitioner appeared in the first semester examination in December 21. She was declared failed in the said examination, which is reflected in excerpt P1, page 30, which is the statement of marks of December 21. Thereafter, she was permitted to sit in the ATKT and took the examination in November-December 22. This, we say, my lords, is not entirely factually correct, and probably because of some misrepresentation.
What is the error?
The error, my lords, is I appeared in my first semester examination in November and December 2021. I was declared failed. I was not allowed to keep term. As per the ordinance, I have to be treated as an ex-student. I have to readmit, and I have to sit up for all the papers again. After that, I did that. I appeared as for my first semester examinations without being allowed to keep term for the second semester in December 2022. I cleared all my examinations but for one, which was the economics paper. I again sat up in the ATKT round in December 2023, was unable to clear that. Thereafter, my lords, they interpret it as that is your second attempt, and now you are a failed candidate, so unfortunately...
You see, first attempt you failed.
Yes. I failed the entire semester.
Second attempt, you failed in economics.
And then I was allowed to keep term.
Then you went up to keep term and went in ATKT.
Then I was admitted in...
You failed in economics.
Now, there's a small point in between, Malas, which I'd just like to show. When I failed for the first time in December 21, I was not given admission to semester 2, which of course began. After I failed in December 22, when of course I failed in one subject, then of course I was allowed to keep term, given admission in semester 2, given admission in semester 3. And while I was giving semester 3, because the two terms overlapped, then of course I gave my semester 1 examination, failed in economics again. Now, my lords, when I came up for the second time, it was on my lords' interim order that I was allowed to give the second ATKT examination. That order is 27/125. I have uploaded for my lords in the ERP in the writ petition. If my lords could kindly have that order, there were certain personal exigencies, rather practical ones.
It is not exigency. You failed in economics twice.
I failed in economics particularly twice. I failed in the entire semester once.
That's all right. You failed in one, but you cleared the second semester.
Yes.
It is if you clear a minimum number of papers, you get promoted to the next year.
Yes.
And repeat that first year with the paper.
Yes.
So show us the rule position.
Page 60. Page. This is my lord 62. Now, three rules I'll just point out for my lords. That is, this is the ordinance number 92, which governs the 62, my lords,
Of the
review petition. I tender my apologies, my lords. This is no, it doesn't.
Part of the.
Yes, I'll just upload it for my lords on the ERP.
Part of the reply is.
Yes. So if my lords may just have the ordinance number 92.
92.
Yes, my lords will see it's a rather old, almost typewriter sort of a document.
Yes, ordinance number 92.
Yes. My lords may kindly have rule 3 and 4.
Yes.
If a student fails in 2 or less papers or in aggregate, shall be declared compartmental candidate and may be promoted to a higher semester class. Number 4. A student who fails in more than 2 papers shall, or the aggregate declared fail and, full stop, he shall be treated as an ex-student and has to pass all papers. Now, if my lords will also kindly have 4 and 16. 4 says a student shall be given 2 chances to pass his or her semester exam, and now 16, my lords. No student shall be permitted to execute his or her BA LLB honours course after 8 years from the date of his admission in first semester examination. Now, what I submit for my lords over here is, The distinction is between a candidate who has failed, only talking about the first attempt of the first semester right now. There is a distinction between a candidate who has failed and who is allowed to keep term. That is ATKT, it's an acronym.
So how does this 16 become relevant?
16 becomes relevant, my lords, is because if I am an ex-student, as Rule 3 says, I readmit, and since I readmit, my first attempt becomes the semester attempt which I gave in 2022. Even for the sake, that may be...
This says 8 years, so how is it still relevant?
Beg your pardon, my lords?
You won't be able to complete it in 8 years.
If now, right now, the position is, my lords, that I am yet to clear first semester, which started in 2021, we are in 25 today.
You get maximum 2 attempts in a paper?
I get maximum 2 ATKT attempts in a paper.
Yeah.
Yes.
Not ATKT, you get 2 attempts in a paper.
No, they say that in their reply itself.
To pass his or her semester, 2 attempts, chances to pass his or her.
That has been interpreted. We don't challenge that part of the order. In fact, my lords will see order dated 27.
So you are saying when you are admitted in as an ex-student, that should be treated as your first year.
That is one argument.
That can't be. What happens to the first year? There is no concept of admitting a student as an ex-student in first year.
My only argument before my lords is to apply what will be the effect of the first semester, that is my original admission in which I failed hopelessly. That would be attracted by Rule 16. That is whether or not I am technically trained to undergo the entire course or not, that may be determined from the date of original admission. But insofar as considering for what is the ATKT attempt, that my lords will have to see will operate in the form of Rule 4 and 5. That is only if I am allowed to keep term, if I am allowed to go into the second semester.
There is a question of allowed to keep term in the rules. Rules simply say you get 2 attempts to clear a paper.
Rule 3 is the compartmental allowed. The ATKT as a word is not used.
If a student fails in 2 or more paper, you will be in 2 or less papers, you will be promoted.
Yes.
If your student fails in more than 2, you are
Failed.
treated as an ex-student.
Yes.
And appear again.
Yes.
You are treated as an ex-student.
No, I was treated as an ex-student on the first occasion.
Yes.
Because I failed all papers. Then I gave all my papers, I failed only in economics. Then of course I gave my economics paper again, I was not able to clear it again. If my lords could just kindly bear with me, because it's not completely a meritorious argument, I'll fairly concede where that's concerned. I even hope for my lords is some merciful indulgence, and for that if my lords will see 27-125.
This is not a factual error. This is an interpretation of the rules. We are please be conscious, we are in a review today.
Yes.
This is not a factual error. You were saying you began with this.
Yes.
It is a factual error. There is no factual error.
I'll bow down to that. My lords may just see my second ground. My lords may just see my second ground. I'll abandon that entire argument. My second ground is, my lords, that the university was estopped in arguing the fact that because the ground which weighed with the court for not permitting me was that now, as per the interpretation of the rules, you are supposed to give all your first semester examinations again. Since you've only given economics, that is why there is no question of whether you passed or whether you failed. That's redundant, and there's no question of you being promoted at all, because you've been considered to be a failed student. Now, if my lords will just see, what was not shown to the court in the writ petition was the admit card issued by the university to me. Now, my lords will see, so to say, my third attempt, but on my lords' interim order. I go to give my third attempt, I seek an admit card. The admit card which was issued to me by the university was whether it is for 5 papers or whether it is for 1 paper. Now that admit card I have filed on page 54.
Yes.
This admit card, in furtherance of my lords' interim order, for my second or third, howsoever we read it, that attempt of economics, is only issued to me for economics. So the university gives me an admit card, tells me you appear for the economics examination. And after that, they argue before the court saying that no, now since she's a failed candidate, she's already gotten 2 attempts and she's a failed candidate, she must appear for all the examinations, and whether she passes or whether she fails, this is still not declared.
What was the order that you took from this?
That is, my lords, on
Reference. You were next in
yes, yes.
Petitioner shall be permitted to appear in the fifth semester examination as well as repeat of the first semester examination paper. Yeah, so you sought that permission. We gave you permission to appear in a paper. You have to look at the rules, not us.
My lords, I'll just request my lords.
You gave me permission to appear in 1 paper, so they gave me an admit card for 1 paper.
Absolutely not. I don't argue that, my lords. What I submit before my lords at this juncture is that we appeared before my lords seeking an interim prayer that
you get the economics now after this order, you still haven't cleared.
we don't know. That's what I submit, my lords, keeping everything apart. If I say, if this paper which was given on my lords is interim order, the economics paper, if I have cleared that, I have already cleared 2, I have already cleared 3.
Have you cleared that economics?
We don't have the results, that's still with them.
So, pursue it in that petition now.
No, that petition is disposed, we had a review of that petition, my lords.
No, this petition.
The interim order petition has been disposed of, that's the
This is the same petition.
Yes. So all we say, my lords, is that now the fact that they gave us an admit card for 1, of course, that may be an interpretation that we sought prayer to appear in 1, but again, that's a bi-party order. The university appeared even in 27-1. They could have pointed it out at that juncture itself, that whether she appears for 1 or whether she appears for, she has to appear for all 5.
You see, again, this is the view taken by the bench on interpretation of the rules.
Yes.
If it's an erroneous view, can't be corrected in a review, it's a view taken.
Yes.
What can be corrected is an error apparent on record or a factual mistake. It's
True.
neither.
Absolutely true.
It's an interpretation. You're asking us to reappreciate the rule position and rule in your favor.
No, my lords. What I'm
So do we?
no. I've probably not interpreted myself as well as what I want to. What I submit before my lords is the error which has come up in the order which we seek review of, crept in by virtue of this fact as to whether I am supposed to give 5 papers or 1 paper.
It's not an error.
No.
That's a view taken by the bench at the time of final disposal that you should have appeared in all 5.
That's a view taken on the representation of the parties, my lords.
That's all right.
What I submit before my lords.
Interpretation given by the court that you should have. You see, what you are now saying is that when liberty was granted at an interim stage,
Yes.
it should have been granted for all the papers.
No, I don't say that. I don't cast the burden onto the court, my lords. That will be my last submission.
Issue is not that. Error, whether it happened then or now, it's an interpretation of the rules.
Yes.
At that time, it was an interim, whatever prayer was sought was granted. You said a prayer, I failed in economics, I could not appear because an accident happened.
Yes.
Permit me to appear, court said, all right, permit him to appear.
Yes.
Permit her to appear.
Yes.
Now, when the court in final stage is interpreting the rules, court comes to a conclusion that you should have repeated all the papers of first year again.
Yes.
Oh, that's a view taken.
That's true.
Not a order which can be rectified in a review petition.
My lords, may kindly just appreciate my difficulty because I'm coming up. I understood this.
It's all somewhere else, not here.
May I just propose something, my lords? If my lords are just magnanimous enough to call for my first semester results.
And the court has also in this order, the
Yes.
review of which you are seeking in para 11 says,
Yes.
and or as the interim order made it, should give no equity to arise in
Yes.
account of interim order.
That's also true. That's also absolutely true. But my lords, my lords may give me a minute and let this one argument of mine just pass through. That if I was required to give all 5 examinations, because I am of course a student of law, my lords, I was representing my own case at the time, not that I seek any charity of my lords by arguing that. But what I still submit, my lords, is I come up with my own fangled interpretation of the rules, may be right or may be wrong, and I put up a petition with an interim application before my lords. My lords are hearing me, there is the university who is an entire institution on the other end, and they are represented in that. In that representation, my lords passes an order to appear in 5 as well as 1 examination paper.
At that stage, the whole purpose was I should not be asked to appear in 5, I should only be asked to appear in 1. Because I have clear 4 papers. This was the argument.
Yes.
So the argument was that please permit me to only appear in 1, not in all the papers. What the university was asking her to repeat all the full year. He said no, please ask me to appear only in 1.
If that had, may I submit, my lords, if that had been the case, then there was nothing which would have, at least that objection of the university would have been in the order.
Why should it be in the order? Court is granting the relief to come forward to the
My
court
lords,
for.
I just ask myself a question. I'll just ask myself.
See, if you make a wrong petition, if you make a wrong prayer and that is granted,
Yes.
because that you were liable to appear in 5, you challenge that on the grounds that please don't ask me to appear in 5. University is asking me to appear in 5, permit me to appear in 1. Court said, all right, appear in 1.
Court said appear in both.
Not the 5th semester.
No, 5th semester also.
Of course, 5th semester, you had gone to 5th semester by interim order.
I was in 5th semester, my lords, not by interim order, they were not allowing me 5. In fact, even semester 4 is not declared yet. May I just submit for my lords one submission I just have. My submission over here is, my lords, if this be the fact, now let us see how the court which is, yes.
Please don't make the submission, look at the prayer in the petition. Original petition.
My lords,
Then make your submission.
my lords.
Please read your prayer.
Yes, I'll read it out loud. Because the petitioner is not given the admission, prayer is to issue a writ in the nature of mandamus or any other appropriate writ, order or direction of the respondent to grant the one last chance of participating the examination of first semester in economic subject and given the permission for admission of fifth semester and declare the result of the fourth semester in petitioner.
This is your petition.
That is my petition, my lord.
Your petition is not, I should have been permitted to appear in at the stage of final argument. Court said you wrongly sought it. You should have been asked to appear in the entire first semester.
My lord. If this was my...
This is your petition. This is not an error of the court.
No, absolutely not.
And
I am only...
You can't be because you make a wrong prayer.
Absolutely right. But if my lords may just see it from one point of view, I am of course a law student. I am seeking some sort of indulgence. My only prayer before my lords is, the court...
Sir, Daniel, this all argument of liberal interpretation was available to you when the court was hearing the matter finally.
Well,
matter was heard, a view taken.
Yes.
Right or wrong, can't be corrected in review, that's a view taken in law.
Yes.
If it's erroneous, it will be corrected somewhere else, unless the error is apparent on the face of it.
May I just show my lords one thing which might satisfy that requirement? If my lords may just have the order we are seeking review of. My lords may just have paragraph number 11 thereof. My lords.
Yes.
Now, my lords are of the opinion that the order passed is examination paper, that is economics, because I prayed for that. Now, para 11, the court holds. In this case, the facts aforementioned are undisputed, and as far as the legal aspect is concerned, Learned Amicus also does not dispute that the petitioner has failed in the first semester main examination and despite having taken 2 ATKTs, could not clear the economics paper. Therefore, she had to take the entire semester examination again. As that being the rules, this court, while empathizing with the petitioner, is unable to grant any relief as the petitioner would have to take all papers of semester 1 now to be eligible in the fourth semester. As the interim order dated 27/1/25 made it absolutely clear, just a moment, Mala, this is... Yes, under the circumstances, para 12. Under the circumstances, this court is unable to grant the prayer of the petitioner that she only be permitted to give an ATKT re-examination in the economics paper and not take the entire first semester examination. Therefore, this petition fails and is dismissed. Now, what I submit is, on reading 27/1/25, the interpretation is that I sought a prayer only to appear for the economics examination and nothing beyond that.
So, did you just read the prayer?
Yes. That's apparent. Now, after that, when I came over here, my prayer was that I must...
Not going to prayer beyond the petition?
Of course not. What I submit is that it is only the economics paper which is required for me to pass.
Court has said no, you should have appeared in the entire semester.
May I just show my lords the state's reply?
Again, interpretation of law. This ordinance has been interpreted by the court.
Yes. My lords, the interim order of 27/1/25 was granted based on the candidature of 2 others. My lords has gone through that order. Those 2 others were granted 2 ATKT opportunities beyond the actual semester itself that the state even admits in their reply.
All right, let's assume that court has wrongly passed this order. It's an interpretation given. The remedy is appeal. Not in a review petition, Mr. Daniel. Please understand.
Yes.
We are not looking at this petition threadbare as a fresh petition. We are looking at it from the perspective of a review.
Yes.
Error apparent on record or a factual mistake.
And that is my only submission which I am left with is the interpretation. I'll leave it to my lord's discretion after that.
If there is an interpretation given, you may have a substance. Maybe I agree with you, maybe I don't agree with you.
Right.
A bench has taken a view. Now, if that view is erroneous, it will be corrected by the higher forum, not by the court in the review petition. That's a view taken.
Yes. The last submission which I'll leave my lord with, I'll not bother my lords any further, is the view which I claim to be an error apparent on the record is...
It's not an error apparent on record.
No.
It's an interpretation of an ordinance.
No, my
It
lord.
has interpreted the ordinance to mean that you should repeat after 2 chances, you should repeat a full semester, not 1 paper.
Yes, and I agree with that interpretation. The difficulty is, my lords, that when does the first chance begin?
The first chance began when you first appeared in the paper.
As
You appeared in economic papers thrice. You can't say once I appeared as a regular student, second I appeared as a student, third I appeared as an 80 KT, so it's only 180 KT. That's not the point.
I'll leave my lords
You
with,
had 3 chances at the same subject, you go back.
I'll leave my lords with only one thing. As per Rule 16, now if this would beseech my lords' indulgence beyond the scope of review or within it, I can't say. But if my lords will just see, that is why I read out Rule 16. Today, if I am sent back to semester 1, I in any case can't complete my law, my lords.
You get this error corrected somewhere else.
My lords, this is all of these. Once an amicus was a point, I am appearing trying to help her out in my effort.
On that ground.
Chances of her travelling up north, my lords, to challenge this order.
Mr. Daniel, you were not able to do a job board appointed an amicus for you.
Yes.
You can't.
No, I'm not backtracking on that, my lords. What I submit is, if my lords are to send me back right now to semester 1, in any case, my lords, there's no question, because I can't meet that 8-year standard right now. I'll have to sit up for semester 1 all over again in 25. I've already put in 4 years. Now 5 years, that's 9. I'm between the devil and the deep sea, my lords, over here.
All this argument of prejudice was to be available to you when the matter was taken up for final.
It's true. Could I crave some, my lords, indulgence of my lords? Maybe I know that my scopes do not permit me to crave that. I understand that. But if my lords would be that magnanimous enough, my lords, something can be done. What I submit is, if my lords may just call for that examination, which he is given the 5th semester, the sole paper.
Alright, let's assume you cleared it. So what?
If my lords thereafter,
If you failed, there's no question.
there's no question.
If you've cleared it, what turns on it?
My lords, I may be then allowed to continue onwards of the 4th semester, my lords.
Contrary to the judgment.
No, of the 4th semester.
Contrary to the judgment of this court. Again, it's a view taken on interpretation.
My lords, the
It
only
can be corrected only by way of an appeal, not by us in review.
My only difficulty is, my lords, that as of now, there seems to be no light at the end of the tunnel for the
I
petitioner.
understand your difficulty, but judgment is final, judgment is pronounced. There's only very limited scope of interference after that.
I can only beseech my lords' indulgence to, probably in the interest of the justice, looking at the.
We can permit you to withdraw with liberty to challenge the order on this.
Could I just have it in the passover round? I'll seek instruction whether she wants to
So
travel.
there's not a, we are not, this is not a ground to review the order.
Because we were hoping actually, Millers, that some sort of indulgence would flow from the bench, Millers, to some extent. Probably transgressing jurisdictions to some limited ethical extent is what we submit.